to social work at Lancaster, and this fantastic presentation by Claire, Katie, Julie and Jo. We are going to be recording this session, but we won't, because then we'll be able to share it with you, but we won't be recording the question and answer part of it, so you can be free to ask questions without being worried about being recorded. So yes, my name is Lisa Morris and I'm going to be chairing the session. I am a member myself of the Centre for Child and Family Justice Research, and I'm a lecturer in social work at Lancaster University. So welcome everybody. There's a lot of people here, which I think really reflects the interest in this work, judicial perspectives on care experience girls and women in trouble. So I'm going to introduce the speakers. So we've got Dr. Claire Fitzpatrick, and Claire is a senior lecturer in criminology at our law school, and she's the youth justice lead for our centre. She is the principal investigator for the project Disrupting the Roots Between Care and Custody. She's got a long-standing interest in exploring the links between experience of care and later involvement in the youth and criminal justice system. And she's committed to research that makes a real difference to policy and practice, which I know well from speaking to her over the years. Dr. Katie Hunter is a research associate in the law school. She completed her ESRC funded research at the University of Liverpool, and she completed her doctorate in June 2019. Her research focused on the disproportionate involvement of Black and minority ethnic children and looked after children in the youth justice system in England and Wales. So welcome, Katie. Dr. Julie Shaw is a senior lecturer at criminology at Liverpool John Moores University. Her PhD research looked at the factors that contribute to children and young people in residential children's homes coming to the attention of the youth justice system. Her subsequent research has included multi-agency responses to the criminalisation and exploitation of looked after children, and she's a qualified probation officer. And finally, we've got welcome to Dr. Jo Staines. She's a senior lecturer at the School for Policy Studies at the University of Bristol, and she's conducted research on the use of foster care for young people on remand, adolescent foster care, supported housing for young people involved in offending behaviour, and the use of restorative justice within the secure estate. Jo was appointed to the Prison Reform's independent review of the overrepresentation of looked after children in the youth justice system in Care Out of Trouble, and wrote the accompanying literature review. So we've got 4 amazing women that we're going to be listening to today. And just to say, I don't know if you all know about Teams, you may have used it before, but you can put any comments or questions in the chat, and you can see a little speech bubble at the top, and if you click on there, you'll be able to see the chat. The chat doesn't get recorded, just to let you know, so you'll just hear from the speakers. Okay, Claire, over to you.
Thanks very much, Lisa. Hello everyone, thank you all so much for coming. We are really pleased to have the chance to share some of our findings with you today. So, although many care experienced people do very well, we know those who've been in care are persistently overrepresented in the criminal justice system, and this is particularly the case for girls and women. However, their experiences have been neglected in research. Our project is very much interested in addressing that neglect and highlighting the importance of understanding the potential impact of care experience across the life course. And we start from the position that there's absolutely nothing inevitable about the overrepresentation of those who've been in care in criminal justice settings. The findings we're presenting today form part of our ongoing analysis for a wider study funded by the Nuffield Foundation, and I'm delighted our whole team is here to present today, and myself, Katie, Julie and Jo will plan to talk for about 35 minutes or so, and then hopefully leave plenty of time for questions at the end. This is very much ongoing analysis, so we won't be circulating the slides from today, although the session is being recorded and you'll have access to that afterwards. If you do have any questions after today, please do feel free to just get in touch with us. So much of our work has involved a commitment to learning from the voices of those with lived experience, including care experienced women in prison and girls and young women in the community. But a really important part of this work too has involved exploring professional perspectives. And our particular focus today is on perspectives from the judiciary. I'm going to hand over to Julie now to tell you a little bit more.
Yeah, all right. No problem.
Okay, thank you, Claire. I'm going to begin by providing some background and context to the presentation with an overview of the wider professional sample of interview participants, the smaller judicial sample, along with the ethical process and approach that we undertook when carrying out the study. The key themes explored in the presentation will be firstly disjointed systems, which relates to the fact that care experienced children are dealt with across different legal arenas, depending upon whether the issue relates to care or criminality. And as a consequence of that, there are challenges in terms of communication and information sharing. The second theme will be those of power and powerlessness, and amongst other things, interviewees describe their feelings relating to how far it's possible to influence events and outcomes within the confines of our existing legal system. Finally, participants related their perceptions of dealing with care experienced women and girls in court, including the challenges inherent in this process that often relate to the girls' and women's prior experiences, lack of support in court, and feeling that their voice isn't heard. Claire will then offer some concluding thoughts. Now, in terms of the wider context to the study, there has been a persistent overrepresentation of care experienced girls and women in the youth and criminal justice systems. So, for example, 2012 Ministry of Justice figures revealed that 31% of women in custody had been in the care system as a child, compared to 24% of men. However, the Ministry of Justice figures on women may well be actually underestimates, not least due to the challenges in identifying those with a prior care status in locked institutions. Today, as Claire touched upon before, there's been a relative neglect of the needs of women and girls in the care and criminal justice systems, both in research and in practice. The 2006 Corsten report made 43 recommendations about the treatment of women in the criminal justice system and argued the need for a distinct, radically different, visibly led, strategic, proportionate, holistic, women-centred, integrated approach. However, fewer of Baroness Corsten's recommendations have been acted upon, and it remains the case that the system struggles to respond adequately to the needs of women and girls. This is particularly so for women who have been in care and in many ways end up being failed by both systems. Our research drew upon the experiences of women and girls across different age groups, as we felt that it was important to ascertain and document the impact of the care experience upon criminal justice and other experiences across the life course. Our project consists of 4 distinct data collection methods. We firstly undertook a targeted literature review to explore in greater depth what is already known about this topic and where the particular gaps in knowledge lie. The completed literature review is currently available via the link on the slide. We then moved on to undertake a total of 94 interviews with 3 groups of participants. Firstly, we interviewed 37 women in prison with care experience, followed by 40 professionals who work in various roles with girls and women who have both care and criminal justice experience. And this includes the judiciary participants who were interviewed after the other professionals. Finally, we undertook 17 interviews with girls and young women in the community who have both care and criminal justice experience. Our documentary analysis has involved consideration of the various practice protocols that have been developed in areas throughout the UK with the aim of reducing in-care criminalisation. We expanded this nationally, and whilst some youth offending teams don't have them, we have obtained a total of 37 protocols for analysis. Finally, a further aim of the project is to undertake a data scoping exercise to explore the quantitative evidence base relating to care criminalisation and make recommendations for how it might be improved. So in terms of our professional sample, our wider professional sample, we undertook interviews with 40 professionals in total, covering a range of roles, working with care experienced girls and women. So there were 6 children's services workers, 4 police officers, 7 from the prison service, 4 from probation, 8 youth offending team workers and 11 members of the judiciary. As you can see from this slide, most participants identified as white, so 36 in total, 2 identified as black and 2 identified as mixed ethnicity. Over half of the professional participants, so 24, were aged between 50 and 60 years old, with some younger than that. So we were able to gain a range of experiences in different arenas and across different areas. Our judiciary sample involved us interviewing 7 judges and 4 magistrates. 10 participants identified as white and 1 participant identified as black. There were 6 women and 5 men, and their experience ranged from 5 to 27 years. And our sample largely accords with prior research on the judiciary, which reveals that members are overwhelmingly white and middle-aged or older. However, the sample was balanced in terms of gender. Our sample had varied experiences of different court settings, with some individuals being what was termed dual ticketed, which means that they had experience of working across different courts. So 7 had experience of working within the family court, 5 worked in the youth court, 3 had experience of working in the Crown Court, and 6 had experience of working in the Magistrates' Court. With the disruption caused by the COVID-19 pandemic, it took over a year for us to get approval to carry out the judiciary interviews. So we're very glad to have been able to do these and to be able to share the emerging findings. All interviews with the judiciary were carried out between November 2020 and January 2021. Now, throughout the study, our ethical approach has been very important to us across all interview groups, especially given the sensitive nature of the research. So throughout, we aim to ensure voluntary participation. All participants were provided with information sheets so as to ensure fully informed consent. They knew what they were getting into and what would be required. They were informed of their right to withdraw, so either during the interview or up to 2 weeks after. We always adopted a respectful approach to interviewing. We treated the participants as individuals, taking into account their various commitments. We also developed an adaptable interview style depending on the expertise and experience of individual participants. And we also guaranteed anonymity. The interviews themselves were audio recorded, transcribed, and any identifiable information was removed, including locations. We also adhered with the requirements of data protection, so all the interviews were encrypted, stored on a secure server, only accessible by the research team. Okay, thank you. Now I'm going to hand over to Jo, who will discuss our first key theme.
Thanks, Julie. So hi everybody, it's lovely to be able to be here to talk to you about our research, and starting with the first theme that we'd like to talk about today, rising from our interviews with members of the judiciary. And this is the problem of disjointed systems. And research has shown us that this disjointedness is apparent in the youth justice system, with a number of academics, including people like Barry Goldson, noting our very long history of competing dichotomous perceptions of children as troubled or troublesome, deserving or undeserving, offender or victim. And such conflicting perceptions are apparent across our disjointed legal system and have been highlighted in particular by Sir James Mumby in a number of his public lectures and elsewhere. And he's noted how cases involving children are spread across the jurisdictions, and he's called for an expanded family court which focuses on whole families and problem solving instead of just punishment. And I think that's something that is very much worthy of further discussion. And this problem of disjointed systems was a key theme in our own interview data. And a significant part of this was the challenges of communication across the different jurisdictions. So there's a judge here on the slide talking about this and noting in particular the inability of the two jurisdictions to talk to each other, and how the two different parts of the justice system, crime and family, seem to operate in isolation rather than in conjunction, and how this is echoed in practice on the ground as well. And reflecting on our interviews with care experienced girls and women, it's really clear that disentangling their offending behaviour from their broader welfare needs is incredibly difficult. There's so much overlap between and complex relationships between their experiences, for example, of mental health difficulties, of poverty, of abuse, of experiences in care and so on, and their offending behaviour, that it's difficult to address their offending behaviour without giving consideration to the issues and experiences that they've had. We also found that the amount of information provided about individuals' care experience was problematic and can vary across the different court types, such that different courts may not have a full picture of an individual and their family and their circumstances. So on the one hand, it may be that the family court has lots of information about individuals. For example, one judge that we spoke with talked about a particular case and how they spent their evenings and weekends reading 20,000 pages of documentation. So that's about 3.5 gigabytes of material on their computer for a 29-day case. So they had a huge amount of information to read and absorb and understand. And they said it's finding the time and having the ability to put it all together that's by far the biggest strain. So in the family court, there may be a significant amount of information. But on the other hand, care information about women appearing in the criminal courts won't necessarily be available at all unless someone asks specifically about it or it's raised by the individual solicitor. So the impact of care experience may not be considered or even acknowledged within the criminal courts. Another judge also highlighted the problems of sharing information, specifically regarding children and the way that children can be dealt with across the different court systems, again appearing within the two different legal jurisdictions, sometimes pretty much at the same time, and how each jurisdiction may have different aims. In this example, individual safety for the child, but also the protection of the public, and how difficult it can be to achieve these different aims. So these comments further highlight this problematic issue of disjointed systems and how we think it's important that the two should be much more closely aligned, given that children can move between the two so easily. So as I mentioned, some participants highlighted the lack of information sometimes provided in the youth or adult criminal courts about an individual's care experience. And in general, there was a lack of wider contextual information available, which limited the ability of those in court to make connections between the stories of the past and the present, and to understand how past trauma and care experience may impact on a girl or young woman's current behaviour. But against this backdrop of a lack of contextual detail, there's also the recognition that the behaviour of those in care is often viewed under a microscope. People talked about there being many eyes on the child, and how children in care experience a much higher level of surveillance than children living in family homes, which increases the likelihood of them being unnecessarily criminalised and coming to court. So as the judge here said, children in care are subject to the scrutiny of independent adults, which other children aren't. And while some of the interviewees highlighted that there has been an increased awareness of the need to divert children in care from involvement in the youth justice system, there was a clear sense from our interviewees that criminalisation in some care settings continues. And the number of different care providers involved, the different thresholds in reporting behaviour, responding to challenging behaviour, different approaches to multi-agency working and so on, highlights how and perhaps why a policy practice disconnect continues. Training also emerged as an issue, and whilst there were some very positive comments about general training by the Judicial College, some participants were concerned about the lack of specific training relating to children in care, which was described as by one interviewee as peripheral and pitiful, and a lack of knowledge about the potential impact of earlier experiences of abuse, trauma, and/or experiences of the care system on girls and young women, how it may affect their behaviour, and how it's understood, how it's interpreted, which can affect responses to them in court, which Claire will discuss in more detail later. And other interviewees expressed particular concern about the training of magistrates, remembering that most magistrates are volunteers, so there are implications for how magistrates can be involved in more detailed training, but particularly following the move to online training during the pandemic. And the challenges of multi-agency working in disjointed systems were also very apparent across our interviews. In general, there was a sense that youth offending teams were well regarded and respected by the judiciary, and also by many of the young girls and young women we spoke with. But there were also a number of criticisms that were made of social workers and of the police. And it was also incredibly clear that different agencies were often working to different priorities. So there was recognition that social services are often caught between a rock and a hard place in terms of their access to resources. But one participant also highlighted that they were very aware of a significant disconnect between the youth offending services that want one result and social services that are prepared to fund a particular result. There's lack of coordination between different organisations who are working to different aims and with different approaches and different methods. And in addition to the disconnect or lack of communication between social services and youth justice, comments were also made about the poor relationship between the police and the Crown Prosecution Service. So as one of the judges noted, they said, "I don't understand why the police," well, I do, but not in a good way, "why the police and the Crown Prosecution Service have such a poor relationship. I know there's a national programme at the moment to try and encourage the police to think about diversion, but a lot of the time they're just not thinking about it." And they argued that the Crown Prosecution Service needs a specialist unit for youth work with greater recognition of the impact of the care experience, and that avoids the delay that occurs at every level in the criminal justice process for children in particular. So in summary, the challenges of multi-agency working that have often been highlighted in research were very much reiterated in our own study. But within the context of disjointed systems, these challenges raise some really serious questions about how far justice can be achieved for care experienced girls and women who may move within and between different court settings and between different systems of care and punishment. And I will hand over now to Katie, who will continue with our second theme.
Thanks, Jo. So another emerging theme within our interviews relates to power and powerlessness among our judiciary participants. So Shona Minson's work highlights how the judiciary have been described as an elite who hold power in the courtroom. But actually our interviews showed that many felt the weight of responsibility in the role, particularly when it came to dealing with especially vulnerable girls and women. So Judge 2, when discussing dealing with care experienced girls in court and the impact it can have, said, "Although I'm a judge, I'm also a human being." And similarly, Magistrate 4 also talked about how they would wonder what had happened to the girls after they dealt with them, saying, I lay awake at night still now after all these years. Your heart bleeds, it really does. With this sense of responsibility also came a recognition of the limits of the role. And Judge 1 had said, there's a limit to what I can do and what my role is. And as a sentencer, as a judge, as a magistrate, you have to remember what your role is in all of this. And you are not there to solve these young people's problems. Now, one judge did raise an important point about the power available to them, and in recognising the confines of the role, they also recognised the possibilities for effecting change as well. So one judge had been able to use their power to prevent what they deemed to be unnecessary criminalisation cases being tried in their court. And the way that they did this was through using the absolute discharge as a way of expressing disapproval for cases that they thought shouldn't have been in court in the first place. So they had said, absolute discharge is the strongest message I've found I could give to prosecutors and to the police. Don't bring this type of case, because if you do, there's going to be no penalty. It's the ultimate sign of a court disapproval effectively that they've brought a case that you feel as though shouldn't have been brought. While this complicates the issue of power and powerlessness in the court system, it's worth noting that the power to express disapproval can only go so far. Pragmatically, we can't offer this for everyone, but the wider issue is that it only deals with criminalisation, so the power to criminalise or not to criminalise. So, for example, a vulnerable woman spurred a sentence doesn't mean that she's going to receive any practical help or support in the absence of that sentence, which is something worth thinking about. So many of those who talked about dealing with Kerr cases in either the family or the criminal courts described these as frustrating, depressing, soulless. Judge 3 only dealt with cases in the family court, and they felt that their efforts to assist were in vain. They said, by the time the cases come to family court, it's too late. And I think that's one of the main operational challenges in the Kerr system. Once a case is in the court, it's to what extent you can do anything to improve things. Similarly, another judge talked about it being much easier to deal with younger children. They said, if you're dealing with newborn babies or very young children who suffer non-accidental injuries or whatever it might be that causes them to be the subject of Kerr proceedings, you can actually achieve something. This sense of pessimism about the ability to help older children and teenagers in particular in Kerr proceedings is really worrying. If our judiciary is not confident that they can make a difference in children's lives, then who can be? And these notions that court intervention comes too late was echoed across different jurisdictions as well. For example, Judge 5 talked about their own lack of faith in the criminal justice system. And they'd said, there are some cases that you deal with where you know the only sentence you're likely to be able to pass is a custody-based sentence, and all you're doing then is trying to work out the appropriate length of time for that person to be incarcerated. They said it can be a fairly soulless exercise because you know that they're not likely to get any assistance or support once they're locked up. In some ways, by the time they get to that situation in the criminal court, it's almost too late, even though they may still be young enough to be within the Kerr system or just out of the Kerr system. So these three interviewees' quotes all demonstrate that they feel like their interventions are coming too far down the line for individuals, which is leaving them feeling as though they're powerless to help. So in particular, participants highlighted a tension between these competing concerns over welfare and justice when dealing with Kerr experienced girls and women in their courtroom. So judges in the youth court are actually asked to take account of the complex vulnerabilities when sentencing, but ultimately the role is about justice, whatever form that might actually take. And this was something that was highlighted by Judge 2. They said, when you sit in as a judge in the criminal court, you're not a social worker. The child's welfare is of course paramount, but there are other aspects of the criminal justice system that you have to take into account. Criminal law, it's a blunt instrument, and whilst you take into account, of course, the fact that they have been in Kerr, they're still going to get the sentence that will need to be imposed in those sorts of cases. So it's sometimes frustrating. If they commit serious offences, they will pay serious consequences effectively. And Judge 2 also talked about recognising vulnerability in Kerr experienced girls and women and how this left them feeling unable to help in any meaningful way. And Judge 2 was talking about pre-sentence reports dealing with the issue of self-harm among care-experienced girls and women. And they said, "You feel as though you are powerless in a sense. What can you as a judge do about it? You've only got a certain number of tools at your disposal to sentence, and really you have to allow those that are working with them to try and work around those things." So this sense of powerlessness with regards to girls and women also related to the lack of follow-up with girls in court, girls and women in court as well. We know that professionals working in silos can lead to a lack of knowledge about long-term outcomes unless girls are actually returning to court. This is a theme that was echoed in our professional interviews. So, for example, some of the prison workers that we spoke to told us about, well, they don't know what happens to the women apart from the ones that come back, essentially. So the women that are able to kind of successfully go back into the community and not end up in prison again, they don't see that side of the story. They only see the women that come back. And this was something that Judge 5 talked about in terms of trying to reduce this overrepresentation. They said to stop young girls in the care system falling into criminal ways, they should have a proper mentoring system. But that's the part of the system that I have no control over. My role as a judge finishes when I make the final care order with a plan, whatever it might be. But then that's the end of the case as far as the judge is concerned. You have no more involvement unless there are further care proceedings involving that young person. So, to summarise then, despite the popular narrative that members of the judiciary are incredibly powerful and have the capability to have an important impact on the lives of individuals in their courts, there was still this feeling of powerlessness, or perhaps that the power wasn't correctly placed, and that the participants were not in fact able to make the changes that they saw as being necessary and appropriate for the care-experienced girls and women that they're actually tasked to deal with. And I'm going to pass over to Claire now, who's going to talk a little bit about care-experienced girls and women in court.
Thanks, Katie. Okay, so care experience in court certainly emerged as a common theme in our interviews. As Judge 4 put it, very often women in the adult court have been in the care system for a lot of their lives. In the youth court, I'd say the majority of young women we see have been in the care system. Magistrate 3 went a step further, noting care experienced young women are often used to the system and resigned to their fate. They suggested there's a sense that the system's messed on me all my life and is going to continue to do so. There was a suggestion that young women may be quite aggressive and difficult to deal with. So this links with some of the general literature on perceptions of girls in the youth justice system, with Baines and Adler, for example, highlighting how girls may be perceived by professionals as more manipulative, hysterical, and difficult to engage than boys. So in our research, such gendered stereotypes have certainly seemed to interact with the care status to add an additional layer of disadvantage, with care experienced girls and women variously described by participants as more disrespectful, dismissive, aggressive. For Judge 6, looked after girls tend to be disengaged and to have their own protective shell. They said very difficult to get through to. In my experience, girls in the youth court are worse than boys, much harder to engage, far more dismissive, a tendency either as a defence mechanism or because it's how they feel to be disrespectful. Such comments were echoed by others too, but equally there was a recognition by some of the frustration that girls feel if they've experienced an inadequate care system, when moved a horrific number of times, to use the words of one judge, and when unnecessarily criminalised for minor offences that would be far less likely to come to court if they were not in care. One magistrate commented that already frustrated girls were likely to be further alienated by the court process. So, in many ways, the courtroom may be perceived in such cases as a meeting point between the powerful and the powerless, with care experienced girls and women clearly particularly powerless. But Katie's comments are important to bear in mind here too, as even the judges may feel frustrated and powerless within that court process, despite occupying a position of privilege. One area where it was suggested the judiciary could use their power in court was to try to ensure care experienced girls were appropriately represented and not completely abandoned. For one judge, trying to get an allocated social worker to attend was a particular challenge. And they said, I do better now because I've resorted to, well, if I'm not getting the allocated social worker, I'll have the head of service. I don't do it willy-nilly, but if there's a child who actually appears to be completely abandoned by everything. Interestingly, a different respondent suggested that social workers often lacked confidence in court and lacked knowledge of criminal justice. And in this sense, there was a feeling that some care experienced girls could be impacted by the failings of the system and lack of knowledge of professionals around them. Meanwhile, Magistrate 4 raised the issue of what can happen when a looked after child is accompanied by a responsible adult who is one of the carers in the children's home where they live. And they said it's very difficult if there isn't a good relationship between the child and the person that's come with them, because as well as engaging with the youth, we'd ask the carer questions as well. If there's a breakdown in relationship, the body language between them can speak volumes. Of course, again, often the age of the carer. Sometimes they're not a lot older than the youths themselves. So this magistrate alluding to some really pertinent issues here about who is likely to be accompanying girls in care and how this may be perceived in the courtroom. So the next theme to highlight is communication and trust. And this has emerged as extremely important actually across all our interview groups, including imprisoned women and girls and young women in the community. Judge 5 suggested they'll say they don't want to talk, they don't want to be involved, or they feel they're not being listened to. Similarly, Judge 7 commented on the difficulties around having a voice in court, as opposed to feeling unheard. And they suggested care experienced women often say they don't feel heard in court. It was suggested this is the kind of thing that can get a judge's hackles up because women have a lawyer to speak for them. But this respondent also recognised that actually things may be more complicated than that. And they said if you've been impacted significantly by your experience in care, you've been made subject to child sexual exploitation, you probably think you're worthless. You come to court, you might think to yourself, I've had a rubbish life. You've maybe spent your life not saying that. You might think people think I'm trying to make excuses. Maybe you don't say that even to your own lawyer because you don't think it's worth saying, or you don't think that you will be heard. So what it's about, I think, is facilitating communication, enabling people to speak, persuading them that their voices will be heard. These are really important issues here about enabling people to speak and be heard. It sounds quite straightforward in theory, but can be incredibly complex in practice, particularly if we're talking about girls and women who may have had extremely negative experiences in care, as many of our interviewees had, and especially if they feel they've been failed by the systems intended to care for them. And if these systems have not just failed to help them with past trauma, but may have actually created further trauma. Some of the system's failures impacting girls and women were highlighted by others too. Whilst the judge quoted on the previous slide referred to a perception amongst girls and women that they might not be listened to, two of our magistrates indicated that actually this was a reality for some. So one of them said girls do have specific needs, and if they haven't had anybody to talk to, or I'll use the word mother them, how are they going to learn? I think there are gaps in the system here with children in care. Yes, provide a bed. Yes, provide food, but they also need nurturing, don't they? A loving and being told that somebody cares for them. So in relation to motherhood, this respondent went on to note the vicious cycle affecting some girls in care who later went on to have their own children taken into the care system. And this has emerged as another really important theme in our work, with some care experienced girls and women clearly perceived as a threat, not only as potential offender, but also as parent. One of our judges described a terrible system where care experienced mothers were often left unsupported following care proceedings. Meanwhile, in the disturbing quote by Magistrate 2 on the slide, not having someone to listen to you was highlighted again. They said, I think all the abuse that happened in care homes, all the abuse in foster placements, that hasn't stopped. That's still going on. It's just, I think, when women report it, when girls report it, it isn't taken seriously. It's seen as, oh, you're a child in care, you've been hanging around these taxi drivers. They're at the mercy of the person they've reported it to. If you recall the previous comment, that person may not be much older than the child themselves in some cases. Maybe that person just doesn't want to know. So the magistrate says it must be so frustrating for them not to be able to have someone to listen to them just because there's a stigma, they're in care. So I'll leave that quote there and just move on really to offer some concluding thoughts. What we've really tried to do here is pull out some of the emerging themes coming out of these interviews, highlighting firstly in particular the challenges of having cross-jurisdictional conversations and sharing information, which can be a particular challenge in cases involving care experienced girls and women. So there's a need for far greater integration between the family courts and the youth courts. And so before, there's an interesting comment made in relation to that in the chat. This is also recommended by the Carlisle Inquiry, the Michael C. Foundation, amongst others. This would be entirely consistent with the Youth Justice Board's current promotion of the Child First, Offender Second agenda, and it would also support ongoing efforts to prevent unnecessary criminalisation in care. And there's also, of course, lessons we can learn from other jurisdictions. For example, looking north of the border to Scotland and the children's hearing systems. We know too that Scotland has recently raised its minimum age of criminal responsibility, showing that systemic change is possible and can happen. Another key theme in our work, power and powerlessness. We were struck in some of our interviews by the weight of responsibility that some of the judiciary clearly feel, and the fact that some did feel relatively powerless in these roles, despite occupying these privileged positions. The needs of care experienced girls and women coming to court is really crucial to think about, particularly challenging negative perceptions of these individuals, and gender judgments can clearly interact with a current or prior care status in different ways across the life course. Ongoing challenges also in relation to representation in court and communication and trust. Really, in order to try and improve trust in our systems, our project's highlighting the need to try and disrupt some of the damaging cycles of over-surveillance and inadequate support that may affect care experienced girls and women in particular. Whilst excessive surveillance of girls can lead to them being unnecessarily criminalised at one moment in time, at other points they may be unsupported, in particular in relation to mental health needs, perhaps leaving care support or their own experiences of victimisation. Yet should they fall pregnant or become mothers, the cycle of over-surveillance may begin again. For some women, it may lead to their own children going into the care system, at which point they may well be abandoned as the focus moves on to their own children. So I'm going to just end with one of the quotes from one of our judges commenting more broadly. They said, cases involving looked after girls are frustrating cases to deal with. You know, you just don't know what the answer to the problem is, and the criminal law isn't the answer to it often. Thank you very much for listening, everyone.
Wow, thank you so much for that amazing talk. So moving at times, really powerful. So thank you very much. Would you like to take down your slides and all of you appear on the screen so we can take questions? If anybody's